new realtor title training. This is good stuff. Even if you've been a realtor for a while, it's always good to refresh yourself on some of, like the title commitment and some of the issues with the contract, or I don't want to say issues, some parts of the contract that we look at in the title end. So to get started, oops, went really fast there. We're going to talk about the mechanics of a successful closing. So we're going to, each of these categories: communication expectations, gathering information, working with your partners, title insurance, what it is, because it's sort of a big piece of the closing, and then a little bit about the contract. I do classes pretty much on all of these that are an hour long, so you're getting like a nice little taste of a bunch of different things, and I'm going to try and keep the flow going. But please, if you have questions at all throughout the presentation, use the chat box, let me know, and I'll be happy to answer anything. So the first thing you want to do in any transaction is setting up realistic expectations. National Association of Realtors does a study every year of the different generations and kind of what they want from a realtor. And the number one thing they want is communication. So they want to know, how are you going to talk to them? If it's a millennial, are you going to text them? Is it a baby boomer? You're going to pick up the phone and call them. Setting those expectations early in the program is going to make you not only look like you know what you're doing, but also become a trusted source for your buyer or seller. So find out, how do they want to communicate, and how often do they want to communicate? Do they expect you to call them? Those are the things you want to be asking. You also want to set up communication with the lenders, your closing agent, other closing partners for the timeline of the transaction. When you send over that purchase agreement to Florida Title and Escrow, we're looking at it. We're looking at the timelines, the end dates for title, all of those things. What does the lender have to do? How much time does the loan approval going to take? And finding out how long it's going to take to get even a loan approval. Right now we have this coronavirus thing happening. I don't know if everyone's aware of it, but we've got lenders that are slammed right now with refinances. Are they able to do that purchase money mortgage within a 30-day time period? Are they able to get an appraiser out? These are all the questions we need to be asking. And same with, the title end. Are we able to get to closing in a matter of time? How can we close? Are there options like remote online notary? Is there e-closing? What options do we have? What do our buyers and sellers need to do? Your job really, one of the best things you can do to show your strengths, your skill set, is education. The more you know, the more valuable you are to your clients. Training them. You've got millennials are the largest group of buyers in the United States. They're at like 38% of the market are millennials that are buying homes right now. And the majority of those are first-time home buyers. So this is a great time to set yourself up as that expert. Like, hey, you've never bought a house before. Let me walk you through it. I remember the first time I bought a house, what I could afford versus what I wanted was a big thing. And having a realtor that kind of walked me through and be like, hey, this is cosmetic, or this, you're looking at a house with good bones. Those are things I never thought about. I'm like, I don't like the dish, or the color of the dishwasher, the appliances. It's like, that's not important. That's what your job is to communicate that, train them, educate them. And we're in a market right now, like I said, that's driven by first-time home buyers. They're millennials. It's a great time to step up and show them, how to find a house and what to look for. Gathering information early. So even before you get that listing appointment, you want to know about the property. Is it in the community that you normally serve? Are you familiar with how much the property is valued? Because the first question you're going to get asked is, how much can I get for my house? And you need to be able to answer that. You can check, the property appraiser, tax collector, whatever is for fair market values. Check out what other houses sold for in the area on Zillow or other realtor websites. You can look at Google Maps, make sure the property, see what the property looks like from a bird's eye view. All of those things to get you, when you walk into that listing appointment, you're going to have a lot of knowledge about the property. Also, when you're at the listing appointment, there's more information you want to get. So there's some things that actually are part of the purchase agreement that you need to get. And then there's some things that just here's your checklist, super easy. You want to review the identification. Is this the person that's signing the documents? You know, you have to show your driver's license to pretty much do anything in this world. So no one should have a problem showing an identification piece to you that proves that they are the person signing. You want to ask for the prior owner's title insurance policy. That's actually part of the purchase agreement. If the seller has the prior owner's policy, they have to get it to the buyer within 5 days of the effective date. The prior owner's title insurance policy is a really great tool for us on the title end. In Florida, we have to do a title search that goes back 30 years for a marketable title per the Marketable Title Act. If we have a prior owner's policy, we can just go back to that date of that owner's policy and search forward. We also have this thing called mutual indemnification agreement amongst all the underwriters in the state of Florida. So I work at Fidelity. We are one of the underwriters. We're the ones that insure the documents. And what we've done with the other underwriters is said, hey, if there's an issue, let's say there was a lien or something missed when the seller bought the property and it's not on their policy, we'll use the policy that you issued, First American, and we can clean up that issue. So it saves time in terms of the search because we don't have to go back 30 years, saves time if there's title issues that we need to clear up. And if it's within 3 years, you get a reissue credit on the owner's policy, so you can reduce that policy amount. There's also the prior survey. Per the contract, if seller has a prior survey, they need to get it to the buyer within 5 days of the effective date or whatever date you put in there. And the thing with the prior survey is sometimes we can use those old surveys instead of having to get a new one. Now, there are some parameters on that. Fidelity, we could say the rule of thumb is 10 years and there's been no improvements, and we get an affidavit signed by the seller. And there has to be some certification stuff. But for the most part, you know, even if we don't can't use the old survey, it's not a bad idea to have it so we can be prepared if there's any issues. If there's encroachments or easements that aren't of record and, you know, the buyer's like, absolutely not, because it might take a while to get a survey, you know, and the buyer's like, I want this shed moved off my property, we can at least work on that before closing. So we're not holding up closing to do that. Personal contact information. We talk a little bit about cyber fraud in this course. That's a whole other class and we'll dive into it, but personal contact information is really important. What's your best cell number? What's your email address, seller? Because we have so much issues with cyber attackers coming in and pretending they're somebody else. And of course, the hacker puts their phone number in the email. So we want to make sure we have the most up-to-date info. What's the best way to reach you if there's a problem? Marital status, really important. Are you married? Are you not? And I think if you take any of my other classes, I say this about 5,000 times in every class. In Florida, you're married or you're not married. There's no legal separation. There's no common law marriage. So you're married or you're not. It is black and white. There is no gray area, because you might sit down at a listing and there's a woman there and she'll be like, oh, don't worry about my husband. I haven't seen him in 20 years. Well, guess what? You're still married until you have that final judgment of divorce. So that's just preparing yourselves for that argument, because there is no gray area. Like I said, married or not. If they're going through a divorce, they're still married until that final judgment of divorce. If they're engaged, they're not married. So there's a lot of things that you need to ask, but pretty much if you're married or you're not, big one to ask. Are you a U.S. citizen? We have this thing, which is a whole other class again, Foreign Investment Real Property Tax Act. If the seller is a foreign national, there's a whole list of IRS rules that have to be followed. In a nutshell, there is a withholding of 15% of the purchase price from the seller, foreign national, when they go to sell the property. There's a whole bunch of other rules, but if they're a foreign national, they're going to need to get a tax ID number because they need to file certain documents. So, you know, if they're foreign national, you want to get them to a FERPTA CPA or a FERPTA tax attorney, and know that there might be some delays if they don't have a tax ID number. Luckily, I think we've have so many foreign investors that have been around the block on this that they're used to it. But important to ask you, foreign national. Canadian citizens are not US citizens. I'm just going to put it out there. We get it a lot. We'll get to close and we're like, no, you're Canadian. You are not American citizen. So that's going to delay closing. And sellers do not, for the most part, want 15% of the purchase price withheld, which is a tax escrow that we collect at closing. So let's say they're $300,000, they're selling for $300,000. We are going to have to withhold $45,000, which they'll have to
Karen,
bring
if I
in.
may, this is Ida with the closing team. In reference to the FERPTA, is it 15% if it's over 300,000?
It's 15%
or it's 15% across?
It's 15% across the board.
Gotcha. Okay, thank you.
Yeah. And I can do that class for you guys in the future if you want. And then mortgage loan payoff information, really important we get that. So when we talk about cyber fraud, we're talking a lot of the times about the wire the buyer sends a title company. But now we have a new fraud that's happening. Well, it's probably been around a few months now with payoffs where we're getting fraudulent payoffs. So important to say, hey, seller, who are you paying your mortgage to monthly? We're going to need to get a payoff from them, and the title company is going to work directly with them to get that. A lot of times the mortgage that they bought the house with is not the mortgage that they're paying or the mortgage company they're paying. There's a lot of service transfers. So when we look at the public records, when we're doing our title search, we're going to talk a little bit about that. You know, a lot of times assignments aren't recorded from a mortgage company to the new servicer. So find out who that payoff information. So here's your checklist right here for your seller when you're sitting down and talking to them. Do you have all of these items? Also, just one thing on the owner's title insurance policy, if they don't have it, not the end of the world. Like I said, all the underwriters play nice in the sandbox for the most part, and we can get policies from other underwriters or from the title company that closed. Who are your closing partners? Your closing partners, especially if you're referring anyone, are a complete reflection on you and your expertise, your skill set, your knowledge. You want to establish relationships with those closing partners at the highest level of professionalism and customer service. So who do you typically refer to? You might refer lenders, settlement agent, insurance companies, home inspectors, other service providers. If you're sending, hooking up your buyer with a home inspector and your home inspector is not doing what they're supposed to be doing, guess who's going to get the call? You are going to get the call. It's a reflection on you. So always keep that in mind. Whoever you're surrounding yourself with or referring business to, you better make sure they are the top of the top. You also want to use those closing partners as the experts that in the field that they are. So if you get a question on FERPTA, first of all, do not explain FERPTA to anybody. We want to send them to professional. But if you get a question on FERPTA, you can go to Florida Title and Escrow and say, hey, can you help me out with this? That's what they're there for. That's what we're doing. Definitely closing partners are an extension of your service. So know who you're dealing with, know who you're working with. If you don't know any good lenders, you call Florida Title and Escrow. They can tell you which lenders are great and which aren't because they're doing the closing transactions too.
Hey, Karen, clarifying Florida Title and Escrow is the legal entity. Anytime you're referring to Florida Title and Escrow, it actually means the closing team.
Okay.
That's our name in the company.
Oh, okay. Thank you. Sorry. I just had you Florida Title and Escrow.
No worries.
So what is title insurance? That's what we're doing here on the title end. Title insurance is the insurance that protects the financial interests of the owner or lender of real property. We're protecting against loss resulting from title defects, claims, encumbrances, and other matters. So when we're doing title insurance, what we're really trying to do is say, listen, when that buyer walks on that property after closing, when that lender gets their first lien position, we've taken care of all the issues that may attach to the property that happened prior to them buying it. So that's old mortgages, making sure the correct party's in title, that no one else has a claim of interest in the property. That's what we're doing when we're doing that search on the property. We want to make sure that that buyer, no one's going to come back and say, no, I actually own the property. I have a deed. Or the lender no, I have a prior mortgage that hasn't been paid off. I have first lien position. So that's what we're doing in the title insurance world. You are protected from anything that happens on the property prior to you purchasing it, essentially. But we have two types of title insurance policies in the state, well, across the country. You have an owner's title policy, which protects the owner of record, and the loan policy, which protects the lender. And I know that seems like, oh, well, obviously that makes sense. Owner's policy, lender policy, super easy. But you'll get asked questions like, why do I have to buy an owner's policy when I'm buying a loan policy from your buyer? And the whole point is the loan policy protects the lender, owner's policy protects the owner. The owner or the buyer does not have to buy an owner's policy per law. They don't. It's optional. It's actually on the closing disclosure that it's an optional policy to buy. The problem is if they don't buy it and somebody comes up and says, hey, here's this deed, I own this property, they have no recourse to come back to us and say, I have a claim. Somebody did something on this property and blah, blah, blah. I bought it. Nope, you don't have an owner's policy. We will protect the lender and defend the lender, but the buyer is going to have to litigate it on their own. So that's really the key with the owners and lenders policy. They're two separate policies. Yes, there are two separate fees. If you buy them together at closing, you get a simultaneous issue rate where you pay the full amount of premium for the owner's policy and a greatly reduced rate for the loan policy. It can go, I think, as low as $25. So note that it's a one-time purchase for an insurance policy. You pay it at closing. It covers you the entire time you live at the property. If you pass away, it covers your heirs. It's a cheap insurance for the biggest investment that you're going to purchase. You don't pay it yearly, one time at closing. So that's the sort of stuff we tell buyers, like, hey, you don't buy this, you have no protection. And I get asked all the time, can we purchase the owner's policy after closing? Maybe. I mean, you're not going to get the benefits of it. If you're already bought a loan policy, now you're paying a full premium for a loan policy and then later an owner's policy. And it's not going to be for the purchase price amount. It'll be for the fair market value, which could be much less than the purchase price. So always encourage your buyers to get an owner's policy. We have tons of pamphlets and information on why they should if they ever have questions. But note that it is an optional policy, but they're not going to get any coverage if they don't buy one. So how do we do all of the stuff we do in the title world? How do we get to closing? We actually when you do your purchase agreement and you send it over, we do a title search. We do two types of searches, but the first one we do is a title search, and it's looking at everything that's of public record. It has to be recorded. We're looking at who the owners of the properties are, or the property is, who the if there's any liens recorded against the property, and then we take that information and we create the title commitment, which we'll review in a second. The other search we do is a municipal lien search. We're looking for anything that could potentially become a lien on the property, like with municipalities, like code enforcement violations, special assessments, unpaid utility fees, because we want to make sure those get paid off before or at closing or before closing, so that they're not going to be a problem for the buyer in the future. We want everything, like I said, clean and clear of any potential liens for our buyer. One thing that's not covered under title, which is really important to note, is open or expired permits fall within the inspection period. They are not a title issue. Open or expired permits will never, ever, ever become a lien on the property. They will just sit there open and expired until they're closed out. So it's really important to know that it's buyer's due diligence under the inspection period to find out what open permits are. And when we talk about the contract, we'll talk about the difference between as is and standard, but note that permits do not fall under the municipal lien search. It's not a title issue. Let's see. Okay, let's talk about a commitment. So we've got 3 sections of a title commitment. Like I said, we take all the information that we did our searches on and we create a title commitment. And this is going to be the commitment to insure the policy. It's really important that you review it because there is a lot of information on it that could tell you if there's going to be delays or issues with getting to closing. Schedule A is going to be a review of the specific information of what we're committing to insure in the future. We've got our B1 requirements and our B2 exceptions. So let me pull up a copy of a commitment. Oops. So as you can see, this is Schedule A. This is that first page, which is going to be what we're insuring in the future. Number 1 is the commitment date. This is last day of recording at the county. It's really important on our end when we're getting to closing that that's as close to today's date as possible. Excuse me. You know, we've got to make sure that there's no intervening liens, because we're ensuring that our mortgage that we're insuring is first lien position, and also, like I said, that the buyer is not dealing with any liens that the seller should have taken care of. So we're updating that to make sure that that's as close to today's date as possible. Back when things weren't like electronically recorded and the counties weren't using computers, that date could have been 6 months prior, and now we have a problem because we have 6 months of not knowing anything if anything's been recorded or if there's anything that's going to be recorded. Thankfully, like I said, everything's electronic, so it's pretty much 48 hours out. Then we have our policies to be issued. The first one's the owners. That's going to be proposed insured are our buyers, and the proposed amount of insurance is the purchase price. And I'm going to ask you, if your purchase price changes at all throughout the transaction, that you get that addendum over the title company, because we need to update the commitment with the correct purchase price. That purchase price, this document, this commitment is going to, all the information that's on it, it gets pulled to other documents, the deed. It's sent to the lender for them to prepare their documents. So it's really important that it's up to date in terms of purchase price, you know, name changes, all sorts of things. Then 2B is the lender's policy. So you've got the loan, and then the loan or the mortgage amount is what we'll be insuring. Number 4 is going to be a very important one to look at. This is who is the last owner of record. If you send over a purchase agreement and we see Bob Jones as the person trying to sell it, we do a title commitment, we see Sam Seller as the last owner of record, right there, first indication we have a problem. Who's Bob and where did he come from? And that's going to be in our requirements page to clear that up. So always look at number 4, is that our seller? You might also see a lot of times this is where the marital status question comes in. We're like, don't worry about it. My husband's, you know, hasn't seen him forever. If they hold title as husband and wife and she's just signing off on things, and that's how the last deed of record read was husband and wife, now we have a problem. Husband's going to have to sign off on things, married or not, in the state of Florida. Or if someone's passed away, you're going to find all that on this next page, which is our requirements page. Schedule B, Section 1 requirements on the commitment are all the things we need to get done on title, to clear title, to provide that first lien position to the mortgage company, and to provide that free and clear property to the buyer. So you'll see things on here like pay the premiums, prepare the warranty deed, record it, prepare the mortgage, record it. We want proof of payment for any outstanding assessments, any water, sewer, anything that runs with the land, any, here's the prior mortgage or the mortgage that the seller has currently. We need to pay that off, obviously. The homeowners association, and all these fees and stuff outside of like some of the curative stuff, anything that we have to collect money for, that is going to show on the settlement statement, and we'll pay it off at closing. But some of these things, like this is where you're going to see, let's say Bob Jones is signing the listing agreement, Sam Seller is the one in title. This is where you're going to see deed from Sam Seller to Bob Jones, or whatever it is. You'll find your probate information in there. If we need a trust, whatever we need is going to be in here. And so always check your B1 requirements, because that's going, you might have some of the information, or you can at least get an idea of like, ooh, they're in bankruptcy. We might have to wait a while before we can actually get to closing. And your buyer should absolutely be reading these as well. And then you've got any taxes that are due and owing, because obviously we need to get the taxes paid off. So those are our requirements page.
Karen, if I may, and just so you agents know, title takes care of clearing these items on behalf of buyer and seller. So you guys look at it, so this way you have an idea of what we're gonna need in order to clear title.
Right. So we get through, we take care of all these requirements because we don't want them, if we can't, let's say we can't get an association due or something, that's going to show up as an exception to the policy, and we don't want exceptions to the policy. Neither does the buyer, and the lender absolutely will not allow us to have additional exceptions to the policy. What we do have are the Schedule B2 exceptions, and these are pretty much the standard exceptions, things that are recorded against the property. So let's just scroll down. We've got covenants, conditions, restrictions, easements that are of record for utilities, whatever it is. These are all things that are recorded. We can't remove covenants, conditions, restrictions without, or easements without literally an act of Congress. It's, you know, sometimes easements get vacated and we can get, you know, remove them that way with a bunch of paperwork and stuff, but these are remaining on the property. And your buyer should know, you know, where their easements are on their property. That's why we get a survey too. So we want to make sure, you know, that if they decide to do a do-it-yourself deck and they put it over a utility line, guess what? The utility company can come in and rip out their deck. We also have some standard, or one of the things you'll see is taxes and assessments for the subsequent years, because we only pay up until, you know, we make that we pay the taxes off for the year we're closing, but then any subsequent years the buyer is responsible. So obviously that's going to be an exception, because if the buyer doesn't pay their taxes after closing, that's not going to be covered in the policy. We're just taking care of everything prior to closing. We also have some standard exceptions. Number 3, you've got any encroachment, encumbrance, etc., that could be taken care of with a survey. We are always going to have a survey done on a loan backed file, because the lender requires certain endorsements, and in order to issue them we need a survey, and they want this exception removed. So if we get a survey, we can remove this exception. It's also the great idea to get a survey in a cash transaction, because once again, buyers should know if there's encroachments, easements, issues on the property. We'll also be able to remove B, C, and D. B is for rights or claims of party in possession, mechanics, or any liens for construction, or taxes, assessments not shown as existing liens in the public records. If the owners, we have an owner's affidavit signed at closing and the seller says, listen, there's no other parties in possession, there's been no construction done on the property in a certain number of days, and I don't know of any taxes or assessments that aren't a lien on the property. And it's notarized, sworn document, so that we have that in case something pops up, we can, you know, maybe go back to the seller and try and get it fixed. So know that these are our standard exceptions. So what we do then, we go through all of our requirements and get to closing, pay everything off, do whatever we do. We've now removed this whole requirements page, and this is what the final policy looks like. Now you just have a Schedule A and a Schedule B, and a Schedule A is this is an owner's policy. So this is insuring the buyer. The amount of insurance was the purchase price. And second page is going to be the exceptions from coverage. And as you can see, you've got those restrictions and easements that were on that title commitment. We also have the mortgage that the buyers took out with their mortgage company, because once again, mortgage company is going to be in first lien position. That's what we're insuring them. So that's the, you know, we do these after everything gets recorded. We do an update, make sure there's no intervening liens, and then we issue the final policies. So commitment to final policy, that's what we're doing on the title end. Now let me go back to, oops, wrong one. Here we go. So briefly, Schedule A, effective date, that's that date of recording. We got the policy amounts, the vesting information, that's who owns the property per the public records, and the legal description, that's our lot, sub, whatever it is. Schedule B1 requirements, those sections that we have to pay off, payoffs or any information that we need, water, sewer, all of that. Any outstanding mortgage liens, judgments, taxes, title defects, other issues, all going to be on that requirements page. Exceptions, those are the things we reviewed, things that there's the standard exceptions, which we can remove with an owner's affidavit and a survey, and then the other exceptions like the easements, covenants, conditions, restrictions, things like that. And if you don't know what a covenant, condition, restriction is, it basically tells you what you can and cannot do with your property. I bring this up because backyard chickens seem to be the thing lately. And so if your buyer's like, I'm going to put backyard chickens in my yard, you know, maybe check out covenants, conditions, restrictions to see if you can have a chicken coop. Otherwise, you're violating those. So then after the closing takes place, the policy or issues, like I said, then we have just the Schedule A and Schedule B. So that's what we're doing on the title end. We compile all of that. We make sure we meet all those requirements. You know, we prepare the settlement statement. We get everything to sign off. We fund all of we're making sure we're paying off the correct mortgage. We're getting a release for that mortgage because we want that buyer to not have any issues with anything that happened on the property prior to them buying it. Anything they do subsequently, let's say they don't cut their grass, the buyer doesn't cut the grass when they move in, then they get a code enforcement violation, that's not going to be covered on their policy. Their only recourse is for anything that happened prior. Now, we talked a little bit about the cyber fraud issues that are happening. This is a huge problem in the real estate industry. One of the other classes I do a whole hour on, there's just so much information. In a nutshell, what's happening is the cyber fraud people are hacking into realtors' email addresses because most realtors use free email, Yahoo, AOL, Gmail, Hotmail, whatever it is. And they're easily able to hack into any of those free emails. They get in your system. They follow the transaction, they send an email to the buyer as the realtor saying, hey, here's the wire instructions from the title company. You need to wire your funds now. Buyer's like, oh, my realtor sent me my wire instructions. Awesome. I'm going to send the money. And guess what? That money's gone because it went to the fraudster and not the title company. And this has been a huge, huge problem. We're constantly combating it on our end. And a lot of times realtors like, I don't know, I got hacked into, what do I do? Well, here's the thing. In Florida, and we have Florida and federally, we have laws about cyber security, but it's only if we catch the person that's hacking into your system. So what happened is buyer sends the wire through, you know, the fraudulent wire information that they received from the realtor. Money's gone. It's over in Croatia at this point. And the buyer sues everybody. They sue the title company, they sue the realtor, they sue everyone under the sun. And for a while there, a lot of the cases were getting settled. And we don't have any laws that say, you know, this is what happens if the buyer loses their money from fraudulent wire transfer. So we have to rely on case law. Finally, there was a case that happened out in Kansas. Same scenario, realtor was hacked into, buyer got wire instructions from their realtor, sent the money, money's gone. It was about $200,000. And the court's like, listen, realtor, you're 90% responsible for the loss of their money because you used free email address. You have on your website that you protect the interests, financial interests of your buyer, and that you do all these things for cyber fraud, and you didn't. And so you have to cough up 90% of that 200 grand. And that's our case law right now. It puts a lot of the onus on the realtor. And I don't want to scare anybody, but this is where it comes down to. The easiest thing you can do is tell your buyers over and over and over again, never, ever, ever to accept wire instructions from you. They should only come from the title company. And Ida, I don't know if you want to talk about what you guys do for cyber fraud briefly.
Yeah, well, we send our wire instructions via protected, via a portal that protects the information. They're not able to see it without, they gotta log on. Yeah, they gotta log on to Qualia in order to be able to see the wire instruction.
Okay,
and
cool.
The reason for that is to avoid that, the fraud.
Excellent, thank you. Yeah, I mean, that's really the trick. Every title company, like I said, has really stepped it up to try and protect the consumer and the buyer. But, you know, it happens that buyer just, they're like, oh, it's my realtor. I trust my realtor to do this. And guess what? It's fraud. So I know some brokers have forms that are, you know, warning forms that they give to their buyers that say, don't ever accept wire instructions from us. It should come from the title company.
One other thing, Karen,
Yeah.
also, when you guys get escrow deposits from your clients, The escrow deposit normally comes into our escrow account. Now, some of you may have wire instructions for leasing because you're doing rentals as well. And it just happened to me yesterday. There was a deposit sent, or almost sent, to the account that we have for leasing instead of the escrow account. If that would have happened and I wouldn't have known, we will continue to look for a deposit that we never found. So it's good to get the wire instructions directly from us.
Yes, thank you.
And once you receive it, you should always follow up with a phone call to us, make sure we were the ones that sent you those wires, and verify the wire information that's on there.
Yes, thank you. And if you have questions or you want to learn more about it, here's a list of the Florida Realtors has wire fraud prevention notice you can use. They also have a bunch of information about it. National Association of Realtors does too. And then FinCEN will have you know, some of the cases that are out there. We always like to report them because the FBI will and FinCEN will take all this information and then they do consumer alerts on it. But it's really it's a scary area because now we have case law that kind of puts it on the realtor. So you guys need to be vigilant about letting your buyers know, do not accept wire instructions from me. Okay, let's talk quickly about the Farber contract. Oh, I got plenty of time. I don't use like I'm flying through this stuff. So we've got, there's a bunch of contracts out there, right? You know, Naples has their own, Jacksonville does their own thing. But we have the Farber, which is the Florida Association of Realtors, and the Bar Association contract. So we're going to talk about those because those are the big ones. You've got your standard residential and your as-is contract. And there are some major differences between them. The biggest one is the inspection. So we'll just talk about it right now. So standard residential with the inspections, the buyer has a limited number of inspections they can do. They have to use a professionally licensed inspector. Seller agrees to either pay a percentage or an amount for whatever repairs that need to be done. That's your standard residential. The as-is, buyer can do whatever inspections they want. They don't have to use a professionally licensed person. They have, if they find issues with the property, seller doesn't have to make any repairs. And here's the trick with that. The seller doesn't even have to respond to the buyer. So it's really important when you're using an as-is contract that your buyer knows they have, I think the default is 15 days. So if they have 15 days, they have to do their inspections. If they find stuff they don't like, they need to make that, and the buyer isn't, or seller isn't responding to the request for repairs, they have to make that decision if they want to cancel the contract during the inspection period, or if they go forward past the that inspection date, they are going to be, they're buying as is. They're buying with all those issues. And I bring it up because there was a big case down in South Florida called Diaz versus Kosch, Kosch. And it was a case where there was a buyer was an attorney and the seller was attorney. So good times right there. And they used an as-is contract. The earnest money deposit was around $250,000. So, you know, it was a big house. Buyer did whatever inspections they wanted. They wrote up a list of issues for the seller for repairs. Seller never responded. Buyer called them like some point before closing and was like, hey, did you do those repairs? Seller said, no, I don't have to do any repairs. We used an as-is contract. So that $250,000 escalated to an $800,000 lawsuit, which the judge was like, you sign an as-is contract, buyer, here's your $800,000 bill. Really important to note that because the buyer thought, oh, he's not responding, he's going to do the repairs. Seller didn't respond, seller didn't have to do any repairs. Major difference between as-is and the standard residential. So if you are the selling agent, your buyer needs to understand that. They have to make that decision before that expiration date of the inspection period. Do they want to go forward if the seller is not responding? Now, on the other side, since 99% of the contracts are written on as-is, the as-is contract, most sellers will agree to credits or repairs or whatever, but you want to make sure that if you're doing, if you're sending out a list of repairs, that, you know, if the seller is going to do them, they're done by a licensed professional. So just be cautious of that, and know that that's the big difference between as-is and standard residential. There's some other differences. There's a lot of waiver of liability under as-is with the seller. The as-is contract is used because banks in the REO days were, you know, they were like, I've never lived on the property. We've never lived on the property. No one in my company's lived on the property. We know nothing about the history of it. And that's basically what the as-is says. We know nothing. So just, you know, be conscientious of that. But the inspection period's the big one. And now we have case law, like I said. Knowing the contract, just a couple of the things to talk about. There's, once again, another whole hour class I do on the contract, but these are just a couple things that come up a lot. Earnest money deposit. Where is it? There is a section on both contracts that you put in who's holding the escrow money, where, if it's did it come with the contract, when is it coming? It's really important you fill that out, because sometimes whoever's holding the escrow money is not the company that's closing the transaction, the title company that's closing the transaction. And we get to closing and nobody knows where the EMD is, because it's not filled out. It's important that it is, you know who has the EMD. That's part of what the buyer has to bring into closing. It's a big chunk of it. So fill that out. Also know with the earnest money deposit, title company is not a party to the contract, the purchase agreement. We use the purchase agreement as a tool to prepare other documents, to prepare our commitment to do things, but we don't sign it. So in the commit or in the purchase agreements, if you read it, hopefully you all have, it says buyer and seller do this, buyer and seller do that. And it's between the buyer and seller. If there's, and there's specific language, like if buyer doesn't get loan approval, then this happens and maybe they get their EMD back. The title world, we are not judge, jury, execution when it comes to escrow or earnest money deposit. We're always going to require a mutual release of that EMD. It's really important that you know that, because once again, not a party to the contract. If the buyer and seller are arguing over, like, no, I don't want to sign the mutual release, I think the buyer did something wrong, then that money goes to the court. And then at that point, buyer and seller have to go to court and fight over the EMD. That's just our process. We can't, release. There's a lot of, I remember a lot of litigation because we were like, oh, it says in the contract we can do this. Doesn't say that anywhere, for the title company to take on that liability. So that's just my little side note on that. Then you've got effective date and acceptance. This is section 3. I put the sections that we're talking about. Effective date and acceptance, really, really important to know that effective date is the last signing or initialing and delivery. So you have to deliver the document. Now, this comes up because obviously we email, everyone's in different time zones, all kinds of fun stuff. If you, let's say, email the purchase agreement over at 11:59 p.m. on Saturday night, and it wasn't technically, or no, the contract was signed at 11:59 p.m. on Saturday night, and then it was delivered at 12:01 a.m. on Sunday morning, the effective date is going to be based off that Sunday. It's the delivery portion that's important. Also pay attention to, the calendar days. Especially when you're drawing up a contract and it's like, let's say your inspection period ends on a Saturday, you actually have until the following Monday at 5 p.m. for that inspection period. So it's calendar days unless it falls on a holiday or weekend. And then you go to the next business day at 5 p.m. Time for acceptance and effective date are strictly calendar days. So you can do a holiday, but no, that's a big sticking point. And a lot of people, there's litigation over it as well. When we're talking about the effective date, I always you know, I've got a lot of realtors that do this best practice. They just send an email to all the parties that they all agree this is the effective date, because there's some confusion. Is it the day after that the delivery? And yes, it is. But, you know, you want to make sure everyone's on the same page, because like, look at that as is contract. If the buyer thinks it's a certain date and now they've missed that inspection period and they have all these repair issues, they're on, you know, they're now lost their EMD and they have to go forward with the contract, or lose their EMD if they want to back out. Okay, closing date is section 4. This comes up a lot. Can I put on or before? You can put on or before on the closing date, but the key with that is all parties have to understand what that means. If one party's ready to close before and the other party's not, they don't have to close before. And we see transactions fall apart because of that. It's like, no, we said on or before, I'm ready before, it doesn't matter. Has to be, you know, both parties agreeing to whatever date they're going to close. Easiest thing is to put an actual date in and then do an extension. Occupancy and possession is section 6. It's assumed the seller is going to give their keys to the buyer the day of closing, and buyer owns the house that day. Sometimes, you know, the seller is buying a house and their transaction falls through and they want to stay in the house. They need to stay in the house for a couple more weeks. I will tell you, coming from a title perspective and from a lender's perspective, it's easier to just do an extension of the closing date rather than have the seller move in or stay there through an occupancy escrow. The reason being, the day of closing, that buyer's homeowner's insurance kicks in. And so if anything happens to the property, and this is why lenders hate occupancy escrows, it's on the buyer's homeowner's insurance. So let's say you know, a fire happened or something like that. That's not going to be, and the seller's still living there after closing. Now the lender is going to be out whatever they have to do, and now it's on the homeowner's insurance of the buyer. Easiest thing to do is extend the closing date. If they have to do an occupancy escrow, highly recommend that there's the seller is required to get renter's insurance, so that it'll be a claim on their insurance. Financing is another big piece. This is a big timeline piece. So if there's financing involved, there are certain dates for the buyer to get loan approval. Days 1 through 30, the buyer has to get loan approval. Loan approval means that they are approved to get a loan. There's no contingencies attached to it. That's why you get 30 days. 31 through 33, if the buyer doesn't have loan approval, seller can terminate the contract. Day 34, if nobody, you know, there's no loan approval and seller doesn't terminate, contract moves forward as if the buyer has loan approval. Now, one of the keys with the loan approval piece, and it's really important your buyers read that if they're getting financing, the buyer has to do their due diligence on getting the loan approval. So if they're not, they're technically in breach of contract. You know, everyone's like, well, how are they going to prove it? Well, that's why you go to court and you know, there's discovery and all good fun stuff that costs a lot of money. So if you have a buyer that's getting a loan, you know, you want to make sure that they're working with lenders that understand the Florida contract, and also that they're, you know, moving things along. And like I said, right now with the refis, with appraisers being slammed, with, you know, a limited number of appraisers, I don't know if everyone's back in full force yet because of the coronavirus. You want to double check that a 30-day loan approval process is going to be doable. Title evidence and insurance. Section 9 covers all the closing costs, who pays for what. If the seller picks the title company, the seller pays for the owner's policy. Buyer picks the title company, buyer pays for the owner's policy. There's also a Miami-Dade provision that talks about sellers to provide the owner's policy. They pay for certain searches up to about $250, and then the buyer pays for whatever else. And like I said, it's also there's section about if there's a prior owner's policy, they have to get it over to the buyer. One of the keys, which I have to bring up, is because everything's being electronically signed now and no one's reading the contracts. We've seen it happen a few times where it'll be marked seller pays for the owner's policy, and we get to closing and the seller has this, you know, $800 owner's policy on their side of the settlement statement. They're like, well, I never agreed to this. And then we have to show them the electronically signed contract. They're like, I never agreed to this. I didn't know about that, blah, blah, blah. Well, going back to that Diaz versus Koch, the Florida courts construe these contracts at their face value. They don't care what your intent was. I just did a class on foreclosure, and it's the same thing. You signed a note, you don't make your payment, you're losing your house. It's the same thing with any contract. The Florida courts are like, nope, you signed it, you didn't read it, not our problem. So make sure that that your buyers and sellers are reading their contract and knowing what they're agreeing to, because when closing day is not the day to say, no, I didn't agree to this, especially if there's a lender involved and the seller had agreed to pay for the owner's policy. Guess what? That has to go back through lender underwriting and can delay the closing. Surveys, like I said, 5 days from the effective date if the seller has the prior survey. Special assessments, 9F, this is really important to know. This special assessments, and it says right in the contract, is not for condo or HOA. Condo or HOA assessments are a different rider or addendum to the contract. This is for taxes, for property taxes, essentially, and assessments against the property. These are there's things like sidewalk repair or road repair, things like that that are rolling assessments. So they're usually, they can go up to 30 years, an assessment. And what happens is the assessor comes out and says, hey, we need to put sidewalks in this neighborhood. It's going to cost $1 million. We, at the end of the day, we're not going to, and each house has to pay whatever, $10,000. We're not going to up somebody's property tax bill 1 year by $10,000. We're going to do a rolling assessment over a number of years and just up it like $100 or something. And so those can be pretty hefty, because if you're looking at $10,000 over 20 years, that's not a big deal. But if you have to pay it at closing, it can be. So there is a section, the default language of the special assessments portion says seller pays up to closing, then buyer takes over the payments after that. Prorating it, it's totally fine. But there is a box you can mark that says seller pays the assessments in full. And we see time and time again that the realtor thought that meant the condo and HOA assessments. It is not. It has nothing to do with that. It's really important you note that, because once again, we get to closing and the seller now has to pay a $10,000 sidewalk assessment for a house they aren't going to live in, when they could have just prorated it. And if we have a lender, that has to go back to through the lender underwriting. Just things to think about. These are all the issues that we typically see. We talked about property inspections, that timeline, especially with the as-is, knowing what the buyer can and cannot do, knowing that the buyer has to make that decision if the seller doesn't want to respond to repairs. Do they want to go through it or not? There's a lot of litigation on it. Open permits. Under open permits, on both of them, the seller knows about them. They have to tell the buyer, but under the as-is, the seller doesn't have to spend any money to close them out. Under the standard residential, there is, whatever amount you put in there, but under as-is, they can just be like, yeah, I know about them. Here you go, buyer, close them out if you want them. And they don't have to spend any money. So those are the big sections of the contract. Like I said, there's a lot more with the as-is. It's just waiving a lot of liability, but it's really important you understand that inspection period. And if you do have questions, you're not sure, like, hey, I don't know if this is can I release the EMD here or this or blah, blah, blah. You call your FAR legal hotline, the Florida Association of Realtors. I have the number here. Really important that you give them, they will answer all those questions. They're there for you. They also have on their website frequently asked questions, or you can submit a question to one of the lawyers, but use them. They're there for you. And with that, that is all I have. Are there any questions or? We have one, are there credits available for having a prior policy? Yes. If you have a prior policy, it's in 3 years, you get a reissue credit. The other great thing about having that prior policy, like I said, it can shorten the amount of time for the search and also helps cure some title issues.
The 3 years is for refinances, correct?
No, it's for purchases.
As well? Okay.
No, refinances are like forever, I think.
Oh, refinance is up forever, that's right. All right.
Anything else, anybody? Well, I will send over a copy of this PowerPoint presentation. If there's other topics you want to hear about, just let us know. And like I have a ton of what I just rolled out a bankruptcy one, so that one's fun. But yeah, there's a lot of information out there. Just be really conscientious when you are reading your contracts. Make sure your buyers and sellers read them thoroughly. We live in a world where we sign a bunch of stuff and don't read it because it's like, oh, there's just too many words. Nobody has time for it. They do, because it's very important. And like I said, the courts say, hey, you signed it, you agreed to it. There's no, oh, I didn't read it. So I think, was there one more question?
I think that's it. Yeah. Thank you so much for doing this for us.
Yeah.
Did just want to mention real quick that you guys are going to be doing a few more of these that we have scheduled so far, but like Karen said, if anybody has a specific topic, you can always let us know. In 2 weeks, same day, Thursday, same time, tax sales and tax certificates. And then basically every 2 weeks after that, there's 2 more. Then we have probate and real estate. And then the last one we have scheduled so far is commercial closings. So look forward to those every 2 weeks. And we will see you then. If nobody has any more questions, I guess we can call that a day. Thank you again, Karen and Amy. And we will see you guys soon.
Thanks. Have a great day.
Thank you.